Well, today saw a huge victory. I mean, huge and historic and important. A huge victory for the House of Representatives and a crushing defeat, and I mean historic crushing defeat for President Trump in a ruling by a federal judge in Washington, a judge who wrote, "This court is not prepared to roll back the tide of history." The case is Donald J. Trump versus Committee on Oversight and Reform of the House of Representatives. The president is suing to block Chairman Elijah Cummings' subpoena of Trump financial documents from an accounting firm that has done several years of work for Donald Trump and Trump businesses. The judge ruled that the subpoena must be obeyed, and the judge refused to grant a delay in the execution of his order because the judge said that Donald Trump's lawsuit does not present, quote, serious legal questions about the subpoena. The judge said this is not a serious case. The president doesn't have a chance of prevailing. The president's private attorney arguing the case told the court last week that Congress did not have a legitimate investigative reason for obtaining the Trump financial documents. The judge traced the committee's interest in those documents in detail, beginning with who else? Stormy Daniels. The judge noted that the committee was seeking, quote, documents related to President Trump's reporting of debts and payments to his personal attorney, Michael Cohen, to silence women alleging extramarital affairs with the president before the election. The judge went on to list several other financial matters of legitimate interest to the committee and stressed, quote, Congress's power to investigate is broad. Judge Amit Mehta wrote, it is not the court's role to decipher whether Congress's true purpose in pursuing an investigation is to aid legislation or something more sinister, such as exacting political retribution. Congress's motives are off limits. The president's lawyer argued to the judge last week that Congress is not allowed to conduct criminal investigations. It is only authorized to conduct investigations for legislative purposes. To that, the judge said today, it is simply not fathomable that a constitution that grants Congress the power to remove a president for reasons including criminal behavior would deny Congress the power to investigate him for unlawful conduct, past or present, even without formally opening an impeachment inquiry. Judge Mehta reminded us of the most historic investigations of presidents that began before impeachment proceedings. Quote, twice in the last 50 years, Congress has investigated a sitting president for alleged law violations before initiating impeachment proceedings. It did so in 1973 by establishing the Senate Select Committee on Presidential Campaign Activities, better known as the Watergate Committee, and then did so again in 1995 by establishing the Special Committee to investigate Whitewater Development Corporation and related matters. The former investigation included within its scope potential corruption by President Nixon while in office, while the latter concerned alleged illegal misconduct by President Clinton before his time in office. Congress plainly views itself as having sweeping authority to investigate illegal conduct of a president before and after taking office. This court is not prepared to roll back the tide of history. Leading off our discussion now is Congressman Jim Hines, a Democrat from Connecticut and a member of the House Intelligence Committee and the House Financial Services Committee. Glenn Kirshner is with us. He's a former assistant U.S. attorney who has worked with special counsel Robert Mueller. Glenn Kirshner was in the courtroom last week when that case was argued. And Jill Wine-Banks is with us, a former assistant Watergate special prosecutor and an MSNBC legal analyst who is surprised by none of these developments because she's seen it all before. Congressman Hines, I want to start with you and what this ruling means on enforcing this subpoena against a White House that is trying to block every subpoena.
Yeah, well, it's not surprising. And I mean, you read Judge Mehta's opinion well. Look, two things are coming out tonight. And this is not the end of the story, of course, because the Trump administration, Trump will appeal the judge's decision. But two things are coming out tonight. Number one, Congress is the Article I authority in this country with the power to investigate whatever it chooses. And you know, that stems from something as basic as the notion that Congress is the one part of our government, of the three parts of our government, that is actually elected by the people. And that's why it's Article I. And that's why no matter who you are, whether you're Don McGahn or Mazars or the Justice Department, you don't get to say no to Congress except under Fifth Amendment privileges in the Constitution. And, you know, that is the underlying theory under which Maida's decision came down. And the other thing, by the way, you know, Mnuchin producing tax returns. The law could not be more clear that those tax returns must be produced. So the administration is saying, well, the motives of Congress are not to our liking. You can imagine where the country goes if the question before a court is what the presumably undiscoverable motives of the Congress might or might not be. But of course, Judge Maida dispensed with that today in his decision.
Well, Congressman Hyams, that's so important because on the Ways and Means Committee case in which Chairman Richard Neal is demanding to see the Trump tax returns, which the chairman of the Ways and Means Committee is legally empowered to do, very specific law written that gives him that power. And that law in writing does not require him to ever announce what his actual motivation is. And there's the Trump administration saying, we don't like your motivation.
Well, that's exactly right. And you know, you don't need to be a lawyer to go and read that law. And the law says that the IRS shall, with no conditions, no ways out, shall provide this. Now, by the way, we can have a debate over whether that's a smart law or not. And that's, of course, what a democracy does. But today, the law says shall. And so it's just another example of the administration using process, using the courts, which are designed to protect the innocent and to make sure our liberties aren't stamped on, to, in this case, protect a president whose behavior has been corrupt. And, you know, we will win in the end, but make no mistake, the strategy of the White House here is to draw this out for as long as possible to keep as much adverse information as possible from emerging before the 2020 election. Jill
Wine-Banks, the judge cited your work in the Watergate investigation today and other investigations. And if this ruling holds, the Trump delay by blocking every subpoena strategy collapses.
It does, and it's about time because I think he's really gone way too far now with the total stonewalling. It's one thing to stonewall on the Mueller investigation, but now he's stonewalling on everything. He would totally defeat the purpose of congressional oversight if the witnesses, for example, about the security clearance process can't testify, witnesses about the immigration and children in cages can't testify, if Don McGahn can't testify. These are all things that cannot happen. The judge wrote a very thorough and very well thought out opinion, and I think if anything is clear from Watergate, it's that you cannot just thumb your nose at Congress and you can't thumb your nose at a Justice Department subpoena. And that's what the president is setting himself up to do, is to be above the law and to just say, I'll do what I want to do. And our whole Constitution is based on the fact that people will follow the law.
Glenn Kirshner, you were in the courtroom when this case was argued, and here you have an opinion by the judge in your hands today saying he actually didn't hear any serious issues raised by President Trump's lawyer.
Yeah, Lawrence, I want to borrow a phrase from the Mueller report. Judge Maida's ruling was a sweeping and systematic rebuke of the president's claims that he, one, is above the law, and two, is not susceptible to congressional oversight. When I sat in that courtroom, I was shaking my head because I heard the president's lawyer, William Consovoy, say things like Congress can't investigate a president who violates criminal statutes, and Congress can't investigate a president who violates the Constitution, for example, the Emoluments Clause, and Congress can't investigate a president who may have a financial interest, a conflict of interest in legislation he supports or executive orders he authors. And Judge Maida was shaking his head. He was being polite, but you could see he was buying into none of it. So when I see him use a word like your arguments were unfathomable, I was fully expecting this kind of an opinion to be handed down. What I wasn't expecting necessarily, Lawrence, is that it would be handed down so quickly. Let me tell you, after 30 years in courts, including decades in the courts of Washington, D.C., rarely do things happen quickly. But the fact that Judge Maida handed down this decision in 6 days is pretty remarkable. And now just 2 days from now on Wednesday, we're going to see Judge Ramos in New York get to handle the exact same issue with respect to congressional subpoenas for the president's Deutsche Bank records and his Capital One records. And, you know, Judge Mehta's ruling is not binding authority or precedent for what Judge Ramos will do, but it is extremely persuasive, and I fully expect Judge Ramos to rule the same way, and hopefully just as promptly. I do think the sort of dam is breaking at this point, and this is a great day for transparency and for accountability, but a really bad day for the president's seemingly endless attempts to cover up his own misconduct.
Congressman Hyams, to the 2 points that Glenn made. One, an opinion issued with remarkable speed, especially when you read it and you see the depths of the scholarship, the legal scholarship going back to 1860. This is the kind of opinion that, even though it's written by a district court judge, you can tell this judge is hoping that other judges are going to read this opinion before they have to rule on what will be other Trump subpoena blocking attempts.
Yeah, no, and that's right. And look, I guess the speed can probably be attributed to at least two things. Number one, a consciousness of the fact that process is being used here to block the constitutional prerogatives and authorities of the Congress. And I would like to believe that most members of the judiciary would be opposed to that. But look, you know, if you're not a lawyer, at some level you can understand the absurdity of the arguments that were made before this judge. Remember, I mean, all of 4 or 5 weeks ago when the Mueller report came out, the Mueller report said it showed deference to the Office of Legal Counsel's opinion that the sitting president cannot be indicted. Now, again, we could have a long legal debate over that, but let's just assume that they're right. I'm not sure they are, but let's assume that they're right. If that is true, if the Justice Department Office of Legal Counsel is true, then the one other body on the planet that can hold the president accountable, and there's no question that our founding fathers and the Constitution wants to have a mechanism to hold the president accountable. At some level, that's kind of what our country is about. It is Congress that will do that. And then to turn around and say that Congress does not have the right to execute the very authorities that create the OLC opinion that the president cannot be indicted is, I mean, again, to a non-lawyer, it's absurd on the face of it.
Glenn, to go back to your point about the next subpoena case being in New York City. It's inconceivable to me that any judge sitting on any of the other Trump subpoena cases that come along, including this next one, would not read this opinion because they're going to have to, if they're going to rule in another way, they're going to have to take on this opinion.
Yeah, it's inconceivable to me as well, Lawrence. I'm confident that other judges will read it, and it's also inconceivable to me that they will depart from the reasoning in Judge Mehta's opinion. Listen, I was in the court for Judge Sullivan when he took General Flynn to task for basically selling out his country, and then being in court watching Judge Mehta take the president's lawyers to task for making unfathomable, unsupportable arguments. It leads me to conclude, as I have believed for 30-plus years now, the state of our judiciary is strong, and I think now that these matters are moving into the courts will not endure or endorse the games that the president and his administration and his underlings and his enablers, like Barr, have been playing for so long, trying to keep these matters under wraps. I think we're going to begin to see what it is the president has been so deathly afraid of the public seeing.
Jill, quickly, is this an indicator, with your experience in Watergate and delay tactics by a president and eventually getting where you had to go, is this an indicator for Democrats in the House that they should actually move to court quicker?
Yes, I think it probably is. I want to point out, to follow on something Glenn said, that speed of decision frequently happens when there is a huge public interest and public need. In Watergate, we tried this Rule 6 exception to give the information to Congress, and we did that on March 1st, and by March 26th, Congress had all of the evidence, all of the grand jury information, the tape recording and the transcripts. It only took that short a time. And even when we went to the Supreme Court on the tapes themselves, it only took 3 months. So it can happen in a very speedy way when there is a need, and there is definitely a need here. And I don't think you need to declare impeachment. It certainly strengthens the case. But as you were pointing out, for example, on the tax returns, doesn't even have to be a legislative purpose. That law was created so that the Congress could look at conflicts of interest without any legislative purpose other than seeing whether there was such a conflict. And we need to really get acting on this. And I think Representative Nadler has taken a very strong stance against the McGahn subpoena denial. And I think it's time for Congress to really do it. Yes.
Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.